Hey there guys, I've been doing some videos over the weekend for my forthcoming course on employment law, and the subject that I'm covering in this video didn't really fit with any of the other topics, so I just thought I'd do a separate video for it and just throw it up on YouTube. If you are interested in following the employment law course, then make sure you're subscribed. I'll do another video when it's ready to be released. I think it will probably be just before Christmas. Anyway, whistleblowing falls under the Public Interest Disclosure Act from 1998. And basically what this did was added some new sections into the Employment Rights Act from 1996 and gives a lot of protection to employees who want to whistleblow on their employer. So enough from me, let's just get started and see how it works in practice.
When it comes to whistleblowing, there are three things that we need to be on the lookout for. First of these is it has to be a qualifying disclosure. Secondly, it must also be a protected disclosure. And then finally, as part of this lecture, we'll also consider the protection for the worker that is available as part of the Employment Rights Act. So first, let's start off with a qualifying disclosure, and what actually constitutes a qualifying disclosure is set out in section 43b(1) of the Employment Rights Act 1996. And I've just listed the 6 things here, and they're the sort of things that you would probably expect to see as part of whistleblowing anyway. Serious things like criminal offence, failure to comply with a legal obligation, miscarriages of justice, some quite interesting ones here, so things relating to health and safety within the work environment, also the environment itself, so obviously climate change is a huge issue, and if a company is, for example, polluting a local river, then that's going to be something very serious, and an employee, or a worker I should say, ought to therefore whistleblow on their employer in that situation. The final category is also interesting. It's whether that type of information is being concealed, and that will also therefore qualify as a disclosure under the Act. So the standard for a qualifying disclosure is that it has to be a subjective standard, so the worker has to show just a reasonable belief that one of the above is being committed. So if we take something like a miscarriage of justice, what we're saying here is there doesn't have to be an actual miscarriage of justice in an objective sense of the word, but rather the worker must have a reasonable belief that a miscarriage of justice is being committed. So moving on, we can look at what constitutes a protected disclosure. And so the worker has to have a reasonable belief that disclosure is in the public interest. And in the recent case of Chesterton Global Limited and Nur Mohammed from 2017, we can see that there are a number of factors that are taken into consideration when considering whether there is a reasonable belief and whether the disclosure is constituting a protected disclosure. So these are the group, size of the group whose interest is served by the disclosure. We often talk about whistleblowing as being in the public interest, but if we are talking about, say, for example, a minor failure to observe a legal obligation, then there isn't going to be as much public interest in that as there would be for, say, a major environmental disaster. Nature of the interests affected, also the nature of the wrongdoing itself, so again, how serious is the wrongdoing that's being committed, and also a relevant factor is the identity of the wrongdoer themselves. If they are the head of a major company, then there's going to be much more public interest in it, even from a media perspective, than there would be for someone who is a low-level employer or from a relatively small company and the wrongdoing is not as serious as it might be for others. So those are factors that we need to take into account, although probably shouldn't place too much emphasis on those compared to the actual sort of disclosure itself. So who is the disclosure made to? Well, it can be made to the employer or the person who is actually responsible for the wrongdoing. It can be made to a solicitor in the course of obtaining legal advice. If we're talking about an employer who is appointed under enactment by the Crown, then the disclosure is made to a minister. And also, thanks to recent regulations, we can see a list of prescribed bodies and persons who disclosures can be made to. That generally includes things like regulatory bodies and local authorities, so people like that. It also has to be reasonable for the worker to make the disclosure, and so there's a few factors that again we can look at here, kind of coming back to the similar points again. So does the worker have a genuine belief that the allegation is true? Are they making it for personal gain? Again, we're sort of thinking about it should be in the public interest, and so if the worker is just doing this for their own personal gain, then it's unlikely that it will be protected for the purposes of the Act. Also, how high is the seriousness of the wrongdoing? Coming back to that similar factor again. Finally, protection for the worker. Basically all we're saying here is that a worker cannot be dismissed for whistleblowing, and that seems fairly obvious, but it is really important. This case of Heinsick in Germany from 2011 is a human rights case that went to the European Court of Human Rights, and it essentially talks about whistleblowing as being protected under freedom of expression under Article 10 of the Convention. And so we see that whistleblowing is really important, and it is going to be a protected right under the Convention.
If you are studying employment law and this subject does come up, it's probably more likely to come up as part of an essay question, in which case you'll have to go through the various different requirements and elements of public interest disclosure or whistleblowing and consider them critically. Think about how they serve to protect employees who do want to whistleblow against their bosses. If it's part of a problem question, then similar thing really, you're just going to have to go through each of the requirements and make sure that the employee has met all of them. Also, that final third point about making sure that the employee is not discriminated against because they have decided to whistleblow. Well, that's all from me. Make sure to like and subscribe to the channel, and also if you have any questions or comments, things like that, then leave them below and I'll make sure to check them out. That's all from me. I'll see you soon. Bye!